Hello and welcome to the Vercammen Law Office Legal Podcast. Look, this edition we're looking at recent criminal cases, and here we're looking at the unreported case of State versus Hall out of Essex County, where the appellate division reversed a suppression grant where the judge had granted the suppression motion, but it was on an issue that was not raised by the party. So in State versus Hall, the state appealed the suppression of evidence, seizing a warrantless search. The police received a call from a woman saying her daughter's father texted her saying men had forced their way into his apartment and she should bring the police. The police entered the apartment and found the father, his roommates, and 4 other individuals, including the defendants. The father stated defendants forced their way into the apartment, pointed weapons at him, and demanded he vacate the residence. The father and the roommate, in this matter, they consented to a search of the apartment for weapons. The police found a handgun and a knife in a garbage can. The motion judge found defendant had automatic standing to file the suppression motion and accepted defendant's position that he was invited into the apartment by someone else he believed owned the apartment. Defendant argued the father's consent to search was invalid because he illegally lived in the apartment. The state prosecutor's office argued the officers reasonably believed that the father had apparent authority to consent. The trial judge held an evidentiary hearing for the limited issue of whether it was reasonable for the officers to believe the father had the ability to consent to the search. The father told police he had a handwritten document purporting to be a lease. Defense counsel argued someone wrongfully rented the apartment to the father and defendant was there at the request of the apartment owner. The motion judge found father and the roommate had apparent authority to consent to the search, but suppressed the weapons because where they were found went beyond the authority either roommate had to provide consent. The appeal court vacated and remanded. So it goes from the law division to the appellate. The appeal court agreed with the state that the motion judge mistakenly granted the suppression motion on an issue not raised by the parties, and the state was denied the opportunity to develop a record regarding the scope of the search. And this is State versus Hall. It's unreported, but the docket number is A-0955-23. For more information on criminal cases, visit website njlaws.com. And for representation, contact Ken Vercammen's office at 732-572-0500. Thank you.